everybody, how you doing? Bill Colarulo. I'm joined today by trial attorneys Catherine Mesiano and Christine Lafferty. It appears that the laws are changing every single minute with regard to this coronavirus pandemic. And again, the New Jersey Supreme Court has now issued another order changing some things that we wanted to come on and talk to people about because this is going to impact your cases. The Supreme Court issued an order on Friday that is close to 15 pages long that covers a long list of things. I wanted to bring Kathy and Christine on because they are litigation attorneys and trial attorneys who can discuss this matter in greater detail. Kathy, one of the things that the order does, and probably one of the most important things, is it has now delayed all trials indefinitely. There will be no civil trials or criminal trials for the foreseeable future. What does that mean for people who have pending cases?
Okay. If you have a case currently scheduled, or if you have a case that you believe was to be scheduled in the near future, they will definitely be adjourned. They are at this point adjourned indefinitely. And that is so that the court could adhere to the social distancing measures as recommended by the state, local, and federal Department of Health. So we don't have a date for any of these trials as of now.
And Christine, do cases require trial to resolve?
No, and we've talked about this before. Trial is the last step. You're at trial because the case has not resolved prior to that. But there are so many steps throughout the litigation process, throughout discovery, where we have chances to settle. So if you have a case that has been stayed because of this new order and you had a trial date set, that doesn't mean that there isn't a possibility for resolution. Like I said, it's the last step. It's where we haven't resolved your case and now we're going to trial. So this really affects those cases only that have not been able to be resolved and are set to be tried in front of a jury.
Yeah, and I've explained this to clients before as well, that if the insurance companies don't make an offer that we think is fair, the last step, our only recourse to try to get them money that we feel the case is worth, is to go to a trial. So if we have a case where there's not a fair offer, we're going to be waiting a little while to get to those juries. And as of right now, we don't know when that will be.
Right.
The other thing that the order did was it really kind of told the deadlines, extended the deadlines when it comes to filing and service of complaints and things of that nature. But one of the things it did not do was told the statute of limitations. Chris, can you touch on that a little bit?
Yeah, so the statute of limitations is different for different types of cases. For the cases that we handle, personal injury cases, the statute of limitations in New Jersey is 2 years. What that means is from the date of your injury or the date of your known injury, you have 2 years to file suit. The only deadline in this order that was not touched on was that statute of limitations. What that means is that if you have a case where you were injured 2 years ago, even from today, you would still have to file suit on that last day of those 2 years because it has not been extended by the court.
Yeah, and Kathy, if you do not file within the statute of limitations, what happens?
You are barred from filing a complaint, but that arises out of that particular injury.
Yeah, so no matter what your injuries are, no matter how strong of a case you may have, if those 2 years come and go, you are barred. Now, the only exception to that is with regard to minors. Generally, they have 2 years from their 18th birthday, so they have until they're 20 to file lawsuits. But the one thing that this did do, did it extend anything with regard to the tort claims notices against public entities? Christine, do you know if it did any of that with regard to the tort claims?
It did. So it extended the tort claim. It's told from March 16 to April 26th of 2020.
Yeah, and what the tort claims notice is that generally you have 2 years to file a lawsuit. But if a public entity is involved, if they were responsible for your injuries, you have 90 days to file a tort claims notice or your case could be forever barred. So this order does give you a little bit more time to do that, but it's important that you abide by these guidelines, or again, you could be missing out on your opportunity to pursue your legal action. Another thing, Christine, that this order touches on is with regard to arbitrations. Now, we talked about trials as being the last resort of a case, the very final step. The step before that that's usually done by the courts is they schedule an arbitration where arbitrators hear the case and then they put a number on it. It's not binding. Either side has a chance to file an appeal of that, and then your case gets scheduled for trial. But a lot of times it will take an arbitration to resolve a case. Well, those have also now all been canceled until April 27th. And then it appears that as of April 27th, they're going to go forward via phone or video conference, which is new. Right, Chris?
Yeah, and arbitrations are super important in our field and to us because, like you said, arbitrations are kind of that last step before trial. It's a very good opportunity for us to resolve our clients' cases. It's where our case is being heard by someone that's neutral that could really help push forward our cases. So not having them and having them kind of postponed and even via video it's going to cause some delays for us.
Yeah, what I'm hopeful happens is that this forces us to kind of change the way that we would normally do things, even when this coronavirus pandemic is over, because usually all arbitrations are in person, all court appearances are in person. And what this order, not only does it say that arbitrations as of April 27th will be by phone or video, it's also encouraging that depositions be done by phone and video and court appearances be done by phone or video. And I'm hopeful that even after this is over, we continue to start doing that, because I think it'll make everything just more efficient. Because Kathy, how many times have you gone down to court for an appearance and you end up sitting there for hours and hours and hours waiting to get in front of that judge? And not only are you wasting half of your day, sometimes your client's there with you wasting half of their day, where if we did it by phone or video, how much smoother would it be?
Very much so. But let me add one thing. For our viewers out there, keep in mind that basically what we're talking about is a civil arbitration. There are exceptions. We're talking about mainly civil here. There are exceptions where if you have a family law case, or if you have an emergent situation with child custody issues, this is not what we're talking about here, because my understanding is the court can still accommodate those type of emergent situations. I think it's very clear that our viewers understand that.
Yeah, we're civil attorneys. We're talking about civil cases. The order does touch on criminal and family and tax and special civil. We are solely civil attorneys, and that's what we're talking about here. Thank you, Kathy, for that clarification. And then the last thing, well, not the last thing, there's many things this order does, but another thing we wanted to talk about was it relaxes the requirement of actual signatures and allows for e-signatures, which has been something that a lot of lawyers have been fighting for a long time, to allow us to utilize e-signatures. I mean, you can buy a home by using nothing but an e-signature, but yet with court documents and different filings, everything had to be handwritten signatures. Well, it seems that they've lifted that. Again, I'm hoping that that continues even when this is all over, because as much as we're going to start seeing delays from a lot of these appearances and things being delayed, by allowing us to get e-signatures, that should help speed things along a little bit.
And our firm is capable of doing that.
Yeah, what's really nice about our case management software, and I'm just so grateful that we had this in place long before this coronavirus pandemic, but our case management software allows us to not only communicate with our clients so easily, we can text message. Every client gets a unique text number that they can text in, and every person that's working on their case sees that text message, the lawyer, the paralegal, the assistant, and they can write in our computer system, text them right back. But what else we can do is we can text message them documents that they can now sign right on their phone and text it right back. It just is so efficient, and I'm just grateful that we've had that in place. And now, man, thank God we did.
Yeah.
Can I just add one thing?
Yes.
Our viewers need to understand, again, the deadlines that we're talking about and the changes to the rules, which are temporary right now, yet indefinite, are again implemented by the Supreme Court of New Jersey. This order, or the two orders mainly that they have created, are to adhere to the regulations both on a local, state, and federal level. And this is because we have to adhere to that social distancing, the measures that they're trying to change. This COVID-19 virus is, as everyone knows who's watching the news and who is mindful today, this is a serious pandemic. The court has to adhere to these regulations by the health departments, and we as a law firm are going to adhere to them. So if our clients think that their cases are being pushed back for any reason, we are not doing this on our own. We're just following the law. If you have any questions, don't hesitate to call us.
Yeah, and Kathy, that's a good point. We keep talking about how this is going to cause delays, significant delays, but in the end, it's for the interest of our clients. It's for the interest of everybody in New Jersey right now to abide by social distancing. So while there is delay, and there will be delay because of this order, the order is to protect us, it's to protect our clients. But the good thing about what we're doing and how we're working remotely is we are still pushing forward and we are still moving cases for our clients. None of these deadlines or extensions mean that we cannot still work with our clients and move these cases.
And it's important that our clients, if you get notice from our firm for a deposition or anything, we need to know if you have capability of conducting this via phone or video dap. And if you are going to do this by video dap and you have that capability on your computer, please understand that some of this information that we're going to talk to you about is confidential. Therefore, you need to be in a private room when this type of a procedure is conducted. You may be talking to a doctor. That is private and confidential. So you need to be in an area where you have privacy and internet capability. So that's,
yeah, and that's important, Kathy, as well, because a lot of people have probably heard the term the attorney-client privilege. And anything that you say to your attorney is privileged. It cannot be disclosed to the other side. However, the attorney-client privilege is only in effect if it's just you and your attorney in that room. So if we're doing video conferencing, yes, that's attorney-client privilege. But if there's someone else there listening to our conversation, that may lift that privilege. And now everything we discussed could be discoverable. So that's a great point, Kathy. It's important that when our office calls you and we say, hey, we're going to do this via video conferencing, that you know you can go to a private place where we could have that attorney-client conversation that will be privileged.
And that flows over into your doctors. Not only in the legal community do we require doctors' exams. They are permanency exams from the plaintiff's side and defense exams from the defendant's side. If you are doing a video conferencing with a doctor for that reason, you need privilege. You need privacy. Even if you don't feel good, putting aside what we're doing here today, if you're not feeling well and you have to do a conference with your doctor, you should be doing that in private. Just food for thought.
No, good points, good points. But, we said this the last time when Chris and I came on at the last order that was issued by the Supreme Court. As much as this is affecting our clients and it's affecting us, we understand it's for the greater good of the community. We talk about our values a lot as a firm, and one of our values is community. So we're going to do everything that we need to do for the betterment of our community. So that's what this is. We will work around it. We will keep pushing these cases as hard as we can. It appears that the court is putting things in place to allow us to do that with phone and video conferencing. Really, the only thing that's up in the air right now is trials. When will they get scheduled? How will they get scheduled? That's a little bit tough to do via video. A lot of times you need to have the jurors there in the courtroom, but we'll see what happens and we'll continue to keep you guys updated.
I want to add something to that, if you don't mind. In lieu of trials, we may be trying mediations or trying to conduct your case to get it to the final and via mediation. And that may be a better thing to do versus trial. Number one, you save on some costs. Number two, you don't have a jury. We usually use a retired judge. And number three, we can do that via video conferencing to avoid that in-person contact by requiring us, our client, and a jury pool. So keep that in mind that we may be trying to use mediations, which are good.
Great point. Yeah, mediation, what's nice about that too is it's not binding. We would usually get in a room together, but we would be on probably a video Zoom call, and the retired judge or a mediator who could be an attorney, they try to facilitate settlement negotiations to get the case resolved. It's not binding. They're not going to make any final decisions, but it does allow us a lot of times to hopefully get your case to resolution, which is the most important thing.
Another avenue to resolve the case during this pandemic.
Well, guys, I appreciate you coming on this Sunday afternoon to talk about this. I'm sure we'll be back on soon because things seem to be changing every day and every minute. But thank you for your time, and we'll talk soon.
Thank you. Stay safe, everybody.
Thank you.